Having me. I'm happy to be here to talk a little bit about this lawsuit. My reaction when I first got this call in November of 15, somebody said, well, "What's going on with the Indians up there?" And they told me about it. I thought, "What a bunch of garbage! This can't possibly be real," and so forth. Well, then I wound up having some conversations, and the next thing you know, I was pretty involved. Let me just briefly tell you what my role is, and it's strictly as a volunteer. There's a group up here called the Emmett County Lakeshore Association, which I don't know whether you guys are members of it or not. I'd never heard of it before. It's been around since the early 70s, and it pretty much runs from the edge of Harbor Springs, maybe up to Sturgeon Bay. They were formed in the 70s for preservation of the area and so forth, and they're the ones that saw the little blurb in the newspaper announcing this suit. It was filed in August of 2015, just kind of under the radar. It was filed down in federal court in Kalamazoo, Michigan, and nobody really paid much attention to it. Well, they started looking into it and found out that there's really something there. The two leaders of the Emmett County Lakeshore Association are Gary Rentrop, who's a lawyer from Bloomfield Hills who works mostly up here, and Lou Kosiski. I don't know whether you know Lou's name or not. Lou's pretty well known up here. He's the guy that runs around giving lectures on the Mount Everest. He was on the mountain, wrote the book, and he was there when all those folks died. In fact, his guide died that day back in 95 or 96. It's the subject of John Krakauer's famous book, Into Thin Air. Lou is a retired lawyer from downstate also, and he and Gary are the two leaders of the Emmett County Lakeshore Association. They started meeting with Jim Raymer, who's a local lawyer here. Many of you know Jim's a terrific individual, does a lot of work for our association. And the next thing you know, somebody said, "You ought to call him." So then I called Lou, and he gets me involved. And right now there's a group of maybe 8 of us, all volunteering. None of us, Lou's former firm is representing us, but none of us have any pecuniary interest in this matter. We're just trying to get the word out. We have a guy named Clark Elwood, who's from Bay Harbor. We've got George Ash, who's a retired lawyer from, I want to say Chicago. He's working with Walloon Lake Association. I'm been involved with the Weekly Tonsing Association, the Weekly Landowners Association, and Harbor Point a little bit. Anyway, we're just trying to get the word out. So that's sort of my role in this thing, is just an advocate. A little bit of a Paul Revere role, because so many people don't know about this, and there's been little in the press. Last year I went around and made a number of presentations after I got to know the lawyers a little bit. The law firm representing the Emmett County Lakeshore Association is Dyke & McGossett out of Detroit area, as well as nationally. And they have strong contacts in Lansing. Their lead lawyer for substantive law is a guy named Lance Bouldry. He knows Indian law in and out. He used to represent Governor Engler in these matters, and it turns out he's got a particular passion for this case because he was born and raised in Petoskey, which is terrific because this is not some long distance out-of-sight client. This is somebody who's emotionally engaged. The lead litigator is a guy named Jim Feeney. He hasn't been that involved yet because we're not in the trial stage or the deposition stage yet. So those are the 3 entities. It's Emmett County Lakeshore, Protection of Rights Alliance, and Protection of Rights Alliance Foundation. You can send those around. And those entities are all involved on behalf of the private interests, on behalf of me and you and the businesses in town and Petoskey and so forth. Every other defendant in this case is a governmental enterprise. Starting with the brief history of this case, as I say, it was filed in August of 2015, and the only named defendant, the tribe filed the lawsuit, and the only named defendant was Rick Snyder, governor of the state of Michigan, because he represents all the governmental enterprises. What happened next was the claim is covering northwest Michigan, basically. It's 337 square miles up here, including, Jim, you probably would have circulated one thing that had a map, but it basically runs from Wilderness Park all the way down the shoreline, 102 or 103 miles, to the bridge at Charlevoix, and then there's the map right there. and everything in green, if you can see that, is what the tribe is claiming as a reservation. And
how did they make that determination?
well, they're looking at these treaties of 1836 and 1855, and they say those are the lands described within the bounds of the treaty. So that's where that land came from. That's where that description came from. So, as I say, the governor was the only named defendant. Then various governmental enterprises moved to intervene. They said, we want to be a defendant too, because if there's going to be any talks about how this case proceeds, or if there's going to be settlement talks, we want to be represented. So the groups that came in were the city of Harbor Springs, the city of Petoskey, the county of Emmett, the county of Charlevoix, 10 townships, because that map shows that not all the townships in Emmett County are covered, but 10 of them, I believe is the number, were. And the tribe said, okay, come on in, you can be parties defendant. So that wasn't contested. Then the Emmett County Lakeshore and Protection of Rights Alliance came along and said, well, that's all government defendants. We need some private interest representation. The Indians said, not so fast. They didn't want us at the table. I think they were hoping to cut a deal where the governments might capitulate here and there, and we wouldn't have to worry about us. But the judge held a hearing on it and granted our rights to intervene, and so now our groups, all of us, are now at the table under the auspices of these defendants, these organizations, and Dykema-Gossett is representing our interests. So that's
Birchwood involved in your
Birchwood. We don't have a representative from them, from their place, but they have circulated the materials that Joe just held up there. That green map and that article was prepared by Emmett County Lakeshore a year ago. We had a big meeting at Birchwood last August 17th or so, where the two lawyers from Dykema-Gossett came up. We had 160 some people showed up at that lunch, and it was packed. But they have not been involved as an association.
So the courts recognize this group as an intervener, not just an amicus.
Right. No, yes, we are parties defendant. Right. Yes, not just an amicus. And so the nature of the case, as you can see there in my overview section, the third bullet point, it's essentially a case of contract and statutory interpretation, at least initially. And I'll explain that at least initially later, but it's interpreting the Treaty of 1855 and a Congressional Act of 1872. The relief the Indians are asking for is the declaration of this 337 square miles, 216,000 acres, as a reservation, and then they're asking for equitable relief, which would bar the various governmental authorities from asserting jurisdiction over the tribe or its members, or interfering with the rights of the tribe and its citizens to be free from state law and regulation. Well, there's a lot to read into that. They are not claiming land ownership as an issue. We'll still own our land. It's just that the land we would own if they were to win this would be within the boundaries of a reservation, which changes a lot.
Do we get the rights of an Indian too?
Yeah, I don't think so. Only the Indians get those rights. Then you can see I covered the intervention part there. In the second part, the current status of the case. One of the big things that occurred a year ago was the Obama administration Justice Department did not intervene. That could have been a real problem for us. Fortunately, that deadline has come and gone. I doubt if the Trump administration would intervene, but even though there's a deadline passed, our lawyers tell us there's almost no way a federal judge would keep the Justice Department out if they decided to come in. The tribe filed a motion last year to limit various defenses that we had wanted to raise, and in fact did raise in the answer to the complaint. And the upshot of that was the court divided the case into two main phases, and the first phase has two parts to it. And this is your talking points for cocktail parties if you want to explain this to people in the simplest possible form. Phase 1, if you flip over to page 2, is Phase 1A is, was a reservation created? That's going to be the first question. As you can see from my outline, they're going to examine the language of the Treaty of 1855. Unfortunately, to the extent there's ambiguity in there, the ambiguity is construed against the government and in favor of the tribe. So that's what I say, what was the tribe's understanding at the time is going to be a big question. As you can see, our argument says nothing in the treaty suggests the federal lands were being held by the tribe under federal and superintendents. All the Congress did was temporarily withdraw the land from the public, sale to the general public, and then let tribal members select land out of that area, but it did not create a reservation. But that's the first question. Was a reservation created? Obviously, if the answer is that is no, we're extremely happy. The case is over, except the other side guarantee going to appeal to the federal court down in Cincinnati. If the answer to that is yes, then phase 1B is, okay, a reservation was created. Did Congress ever undo the reservation? Because Congress is the only one that can undo a reservation. It's not up to anybody else. So if you lose A, you better win B. This 1872 Act would raise some questions about if a reservation was created, was it terminated? If you lose both of those, then you get to phase 2, and we don't want to be in phase 2, because phase 2 then becomes the questions that'll come up then are, to what relief is the tribe then entitled? And that's going to come up over a period of years, one by one. I'm not subject to nuisance laws. I'm not subject to zoning laws. I'm not subject to taxing authority. And when you start thinking about those, people say, well, like I got this reaction weekly counseling. I said, well, yeah, but we own our land. I mean, it wouldn't affect us. Well, yeah, I mean, guess what? If you own land next to a nuclear waste dump, you're affected, even though it's not your property line. And if to the extent tribe owns land or tribal members own land within the boundaries of a reservation, they can do anything with it they want, pretty much. I mean, there are very few limits on that. So it becomes, the technical term is Indian country. That's what the federal statute refers to it. I know everybody wants to be politically correct, but that is the legal term, and that's what the Indians pleaded as. So to the extent the tribal members or the tribe itself owns land within the boundaries of the reservation, it's essentially what they call a domestic dependent nation. They have sovereignty subject only to congressional control. And that's a big risk for all of us. When you think about various cases we've run into, there's one up in upstate New York where the tribe reached a deal a number of years ago. They got some land, they negotiated a settlement with the state and the government, the federal government, I guess, and they got this land, and they said they wouldn't do this, they wouldn't do that. And one of the things they said they wouldn't do was put up, all-night gas stations and cigarette shops. Well, they've changed their mind, and they're putting those in. They can sell gas for 42 cents a gallon less because it's not subject to taxes, and they can sell cigarettes in New York State for something like $5 a pack less. Now, how do you think the neighboring 7-Elevens are going to do competing with that? So those implications are there. In any event, phase 2, as I say, is basically equitable relief. What can the tribe do? What do they not have to comply with? When you go back to page 1, as I said, under the 4th bullet point, relief sought. They're seeking to keep the state and local governments from interfering with the right of the tribe and its citizens to be free from state law and regulation. Your mind can wander into what those scenarios might be, but none of them are going to be good for those of us who are still going to be bound by those laws. I will answer